I beg to make a mention of item 11 of the hearing list. Taken the consent of my senior, if it is listed after 3 weeks.
There's some bereavements there in the family.
3 weeks, Mullah, if it can. I was praying for 3 weeks, Mullah, subject to my life.
I think this is an old case.
Yes, sir, Mr. Mahanto, you just say. If you have objection, we will not, and if we do not object, then we will grant him.
All right, then 3 weeks.
Let's say on the request made his petition or disseminate after 3 weeks. Yes.
Always.
Yes.
May it please, Lordship. Lordship, I beg to mention item number 14, Lordship.
Item?
Item number 14, 1-4, Lordship. It's criminal appeal, Lordship.
Yes.
I found difficult this, Lordship, after 2 weeks, Lordship.
No problem.
The accused is in custody.
Yeah,
Yes,
in
Lordship.
custody.
Here I have raised the issue of juvenility. First I'll argue on the issue of juvenility, after that I will argue on merits.
You are praying for 2 weeks.
2 weeks.
2 weeks on the prayer made by appellant. Let them have that. Yes.
Your Lordship. May please, Lordship. Lordship, I beg to mention item number 12, Lordship. For a week's, my Lord.
There's a matter where you said that a similar matter
Yes, my
was
Lord.
disposed of by division.
In fact, on the last occasions, Learned Senior Counsel had apprised about the report. So, based on that, my Lord, he'll make a small submission. So, if my Lord may have this matter next week, my Lord.
Next week or 2 weeks. Let it be 2 weeks, Your Lordship.
Okay, on the request made by the petitioner, list this matter after 2 weeks.
All right.
Lordship, I beg to mention item 7 and 8.
Yes.
Lordship, in item 7, we are required to file rejoinder. I'm praying for another 2 weeks' time, my Lordship.
This pleading is not complete in this matter.
No, Lordship, because the respondent 7 came later and filed their counter affidavit.
Lordship, in this matter, what happened in the main repetition was there was an order whereby the counter affidavit filed by the respondent 7 was set ex parte. Then the matter was proceeded on hearing, then it was disposed of. Now we had filed a review, that review was allowed. So now the file is back to, restored back. So we had filed a counter. Now they are supposed to file that.
So that is why how it got delayed.
Yeah,
The 7 and 8 these are connected.
no, 7 is the issue of 7 is the issue of Gaunbora, Lordship, and 8 is the issue of land
Lordship,
parcel.
it's a different,
is saying that
Different matter.
it's a different issue. It's a different issue, Your Lordship, but here the matter is that both the orders are being passed by the CM, and in both the matters they are saying that it has to be referred to a tribunal.
No, but then
Lordship, the issue is totally
District
different.
Council, CM will pass the order. So just because CM has passed the order, is there any reason because of that it should be taken together? I mean, can it be a ground for taking it together?
No, in
Until
fact,
and unless
the subject matter of these two petitions are totally different.
Subject matter are different.
Anyway, but then it appears that there is some order. That is why it is taken together,
Lordship.
isn't it?
Some order was
In
passed.
2022, Your Lordship.
Anyway, so right now, what do you say about their prayer?
Even the last occasion they had prayed for time for
So you are
filing
objecting?
rejoinder.
If you object, we will not grant. We'll take it up. Then in that case, you will go without the rejoinder. You have to file rejoinder in both the matters.
No, Your Lordship, only in item 7.
Okay, 7. MSB Karwanda, Learned Counsel for the petition. 6 grant of further
2 weeks time.
2 weeks time for filing a rejoinder in the matter. A rejoinder affidavit in the matter. The counsel appearing for the respondent has no objection. Prayer allowed, list of 2 weeks. And then what about 8?
8 also we're praying for some time, Your Lordship.
8 will just say list alone.
Your Lordship.
Yes. And where is, what is this? Acha, yes, yes. Is 80 just say list along with so and so.
Highly obliged.
Anytime for private respondent.
Just tell him your name will be recorded.
Please, Your Lordship. Your Lordship, I beg to mention item number 10, Your Lordship. I've informed the counsel for the other side, Your Lordship.
Yes, the other side.
I've informed Your Lordship. They're not here, but I've informed Your Lordship.
When do you want it?
After 2 weeks, Your Lordship.
On the request meet on behalf of Mr. N. Majiga. No, not, is the Majiga is appearing there in this matter?
No, Your Lordship.
I know, just on the request made on behalf of the petitioner, this matter after 2 weeks.
Highly obliged.
Please, Your Lordship, I beg to mention item 18. I kindly pray for 2 weeks' time, Your Lordship.
Mr. Yubin.
Yes, Your Lordship. I'm for respondent number 5.
Yes, Mr. Yubin is out of station. So when do you want it?
After 2 weeks, Your Lordship.
Okay, 18 after 2 weeks on the request made on behalf of the petitioner. Yes.
Deeply obliged.
Please, Lordship, I beg to mention item 23.
Yes.
Lordship, here the conducting counsel is on leave, Your Lordship. I pray that Your Lordship may grant 1 week's time, Your Lordship.
This is what? This is a quashing application.
Quashing, Your Lordship.
You are for private respondent.
Yes, Your Lordship. 3 and 4.
You are objecting to the prayer made by. Are you opposing or you are supporting?
Will be
What is your stand? Have you filed any objection? No.
No, Your Lordship, we haven't filed. We will not be filing.
If you are not opposing, then why should you take for adjournment? Then we will just see here and hear the state.
Your Lordship, kindly grant 1 week's time. The conducting counsel will be appearing.
You have no.
No.
When do you want it?
1
When?
week, Your Lordship.
1 week. You'll do it after 1 week.
Yes, sir.
See, Miss So and so. Learning Council looking for the private respondent number
3 and 4.
3 and 4. Please, so you want a week's time.
Your Lordship, interim.
Miss B. Kharwalam appearing for the petitioner has no objection. Allowed list after a week.
Your Lordship, interim prayer may kindly be extended.
Interim, there is an interim.
There's an interim, Your Lordship. FIR was filed.
Is it not until further order? It is until further order probably. Just check the last order.
Until further. Highly obliged.
May I please, Your Lordship, I would like to mention item number 15, Your Lordship.
15.
I pray for 1 week time since the
Matter regarding settlement in POXO, that is still reserved for judgment.
Actually, that has a connection with this episode. Yes, when?
for 1 week time.
1 week. 1 week will be okay.
Because that the Sumkup website still shows that for judgment or for reserve for judgment.
Okay, just say we'll have
Judgment
it for 2
reserve.
weeks. We'll adjourn it for 2 weeks. We'll just see, await the judgment of these things. Just on the request made on the petition, I'll list this matter for 2 weeks.
May I please, Your Lordship? I beg to mention item number 16 and 17, Your Lordship.
Item 16 and 17.
Yes, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship.
These are connected matters.
Connected matter. The issue are the same, Lordship, but they are different case.
You are appearing for the state.
I am appearing for the
Any interim order in this matter?
No, there is no interim order. POXO matter.
These are petition for quashing.
Washing, yes.
Yes. Item 16 and 17, both on the request of the learned counsel for the petitioner, list this matter after 2 weeks.
Your Lordship, similar prayer for item number 19, Your Lordship.
Who is the state here? Yes. Any interim order?
There is, Your Lordship.
Interim orders? Staying the proceeding?
Your Lordship, this is quashing, Your Lordship, for 82.
No, but then in quashing matter, any interim order? Are you sure?
there, Your Lordship. Interim order.
Anyway, just say on the request made. You have any objection? On the request made with the petitioner? This is matter after 2 weeks. 2 weeks, yes?
Yes, Your Lordship.
Obliged, Lordship.
Well obliged, Lordship.
Yes.
Please, Your Lordship. Lordship, the petitioner and I are making a joint mention on item number 20.
Item 20.
20.
Say a bit loudly. You are appealing for the respondent.
The private respondent.
What should I do?
Lordship, I'm for the state, Your Lordship.
Quashing again.
Quashing, Your Lordship.
How many quashing petitions are filed? If all are allowed, then I think.
In this case, Your Lordship, we'll have to examine, Your Lordship, because their investigation revealed that action of the petitioner is not in a good taste, being a judicial officer.
Lordship will.
Lordship will. That I'll please, Your Lordship, at the time of hearing.
Okay, right now, when do you want it?
3 weeks' time, Your Lordship.
Is it all right?
3 weeks.
Just 2 weeks on the request made on behalf of the respondent number?
3.
Apply.
Yes.
May it please Your Lordship. Your Lordship, I beg to make a mention of item number 5, Your Lordship. Lordship, the prior consent of the petitioner counsel has already been sought, Your Lordship.
Petitioner counsel is from here?
Yes, Your Lordship, Mr. Jha, Your Lordship.
When do you want it?
Your Lordship, after 3 weeks, Your Lordship.
Why so long? I think they will be coming back very soon, or maybe today.
Then after 2 weeks, Your Lordship.
Why are you asking for 3 weeks? There has to be justification for that.
Because there are other matters also, Your Lordship, which are coming after 2 weeks.
2 weeks, not 3 weeks.
Okay, Your Lordship.
2 weeks on the request made on behalf of Dr. N. Marjiga, known as DSGI, appealing for the respondents.
Lordship, Mr. Chanda is online for the petition.
Your Lordship, similar prayer for item number 9.
Mr. Chanda is there in this matter.
Issue. More or less similar issue is also pending before the division bench, where your lordship is also one of the party, my lord.
It's all right. We have adjourned it for 2 weeks. This item number 5. So
can it be 4 weeks, my lord, so that in the meanwhile division bench matter may be.
Let us see. If required, we will just extend it. Let it be for 2 weeks for the timing. We'll just see. Okay.
My lord.
Yes. You said only item. She mentioned about only item 5.
Then I said similar prayer for item number 9, Your Lordship.
So you should wait for that.
Your Lordship, Sir Chanda is for
Without
item number 9, Your
completing
Lordship.
your submission without allowing the court to pass any order. Mr. Chanda, you are there again in item number 9.
I am only in item number 9.
9, Your Lordship.
Oh, then who was there in item number 5?
Mr. Jha, Your Lordship.
Okay. In item 9, Mr. Chanda will be there. It's all right.
My lord.
Much obliged, Your Lordship.
Supplementary process.
Item 9 also same order.
Item number 1.
Yes, my lord. The representation
You
is
can
also
do it
engrossed.
without prayer being granted. You can tell your department at all there is any representation. That becomes your duty to
My
do.
lord, that would have been to my prayer for the day. However, since the council is
No,
not
the
here.
prayer says something else.
Yes.
Prayer says a release. Not
No, my lord,
doesn't say.
release, and also
Say
she has
come
enclosed.
to page 7.
At page
Petitioner
7, my
wants
lord,
this.
I have the application, my lord, which it's pending before the department, my lord. Page 7. My page 7 says so, my lord.
No, that is all right. See the prayer. Where is no?
Yes, my lord, prayer number B. Lordship is referring prayer number B.
Direct the one to release the petition on parole for a period of 3 months.
My lord.
So that is what, not this thing. This is
My lord,
directing.
to this effect, an application is also pending, which they have made a
Petitioner
prayer.
asked this court to pass an election. Anyway, until and unless they are here, we will not pass any order. None appears for the petitioner. Miss Arnie is present for the respondent. All the respondents.
All the respondents, my lord.
List this matter after a week. We'll have it
week,
after. This is a matter for
in
motion.
the meantime,
after.
also,
This will
I'll
come in
try
the
to take
motion
instruction.
thing. Okay. This will be listed in the motion. This is a matter for motion after. Yes.
Daily causeless. Item number 1.
Lordship, I have taken steps upon the private respondent. Now, Lordship, I have put.
May I please, Your Lordship?
Yes, Mr. Paske.
I enter my appearance for respondent number 2, the private respondent.
Yes, and then what will happen after if respondent number 2
is a complainant?
appears? It means like service is complete.
Service is complete. Then a matter may come up for hearing, Lordship.
You'll file any objection, Mr. Anything, Mr. Paske?
I will file my objection here, Lordship.
So let him file an objection, then it will go for hearing.
Question 482 matter, Lordship. This is a 482 matter, question of FIR.
So what is there? They cannot file any objection.
Lordship.
It may not be a regulation thing, but then if they have something to say, if they have any to say about the documents which you have enclosed, they have right to oppose it. Why not?
Lordship. That liberty.
Yes, Mr. Pierre Paske. Pierre
Paske.
Pierre Paske. Enters appearance on behalf of the respondent number 2 and prays for grant of some time to enable the respondent number 2 to file an objection in the matter. Prayer allowed. List after 2 weeks.
2 weeks, Your Lordship.
2 weeks for summation.
List after 2 weeks.
Oblige, Your Lordship.
Highly obliged.
Item number 4. Item number 6.
My lord, this matter, Lordship has heard the matter at length, earlier occasion, and the Lordship
Many matters have been heard at length by this court, you see, but the thing is that once there is a gap, the court forgets everything. So you have to take the pain again and refresh the memory of the court.
But
there is no other option. The court doesn't remember anything.
But I'll just try to refresh my lord's memory, taking a few annexures. It's a land acquisition matter.
This is land acquisition matter.
Land acquisition matter. Briefly, my lord, what happened? For
there was another matter. Hard judgment was delivered. That was
that was Prakash Mohan.
See, this is what happens. You see, matters are.
That is a totally different
See,
issue.
what happens is sometimes one matter is heard in part, the next day, maybe in the same matter, another matter has been heard in part, and you see, it overlapping, it overlaps each other.
In this matter, the interesting issue is both the notice under Section 6 and subsequent notice, their name does not appear. And they're claiming that one
And
notice
when this thing was initiated?
My lord, in 2011-12, government initiated for expansion of the road
Under the
from
old
Shillong to Nongstoin, Nongstoin to Karo Hills. And the 2012, they have issued a Section 4 notification. 2012. So Section 4 notification was issued under the All Act, and they cancelled that Section 4 notification again. And in 2013, they issue a Section 4 notification again in 2013. Now,
When the new act came?
2013 Act with effect from 1/1/2014, and the new Act with effect from 1/1/2014.
This is a proceeding done under the old Act.
Under the All Act. Now, what happened prior to issuance of Section 4? They conducted the survey. The collector, with the cooperation of District Council, conducted the survey. The collector robbed in the revenue officer of the District Council, Karo Hills, for conducting the survey. And there was a joint survey, and they prepared a list of landowners in that chunk of land. There, my lord, they have given reports. My name is not appear, and many names of the others do not appear. So later on, District Council also conducted the independent survey again, because of many complaints came forward, and they prepared a list, and they had given the list survey report to the collector. Now, in the meantime, the extra assistant commissioner also, pursuant to the direction of the collector, conducted the survey, and he also prepared a separate list. Now, with the list, it was forwarded to the government, and the Section 4 notification was out. In Section 4 notification, it was published in 2013. 56 names were reflected, and the proceedings started. Then, within 2 months, Section 6 notification also came, because the government invoked Section 17, urgency clause.
Initial 56 names, your name was not there.
My name was not there. Not there. And within 2 months, my lord, there was no proceeding because the Section 17 urgency clause was involved. So there was no hearing under Section 5A. So within 2 months, they published the Section 6 declaration. Now, Lordship is aware, once Section 6 declaration is published, there is no scope for filing objection. Now, after that, my lord, in Section 6 declaration, the landowner, my lord, 126 name reflected. Now, admittedly, Section 4, only 56 landowners. Within 2 months, it rises up double. I can say almost a double, and publish it. Now, subsequently, my lord, Section 9 notice was issued to me,
to you,
to me, and mentioning my house, Assam type house, the trees, everything mentioned, and asked me to appear before the collector. We went in appear, but on that day, my lord, the officers of the collector informed that you have to wait. Many people are there, so they waited whole day in the complex, in the compound, but they did not call for. So they came back, and the next time, my lord, they put up the representation that on that particular notice, under notice, we came forward, but no hearing was done. So please allow us to appear. That representation was put up before the collector. Collector never passed.
Section 9, pursuant to the issuance of Section 9 notice,
yes,
you appeared on one day, and when you were not heard.
Yes.
Because there was
no
sufficient time.
Yes, they were not heard.
Now, this hearing did not go to any subsequent date.
Madam, they did not put up any subsequent
Hearing
date.
was conducted only on one day.
One day. And no new notice was issued to us. And therefore, they came up with the application.
So it means this hearing was for one day only, and it concluded with that.
Yes.
Then you filed a representation.
Yes,
Since
my
you were not
filed representation, and they asked me to come for inspection of the records.
When this hearing was conducted?
2013.
And when did you file your representation?
My lord, 2013.
What is the gap between these two?
My lord, I'll just show that report. Section 9 notice. Section 9 notice was issued July 2013, and my lord,
the hearing was,
my lord, hearing was fixed on my lord 19 July.
yes.
And it was not heard, and therefore the issue on notice, my party has issued notice on 13 September 2013 itself.
August, September.
Yes, within 2 months or 3 months. My lord, the villagers, my lord, they responded in that way. And
when the award was published?
Award was it was within our knowledge, but my lord, we make a specific averment that award was passed in the year 2013-14. 13-14.
What is the exact day of award?
But award, my lord, because of that, lordship directed the learned AAG and GA to obtain that particular date instruction with regard to that and placed before this court. Because of the adjournment was
it the issue before this case or the issue before that other case which was disposed of? This dispute with regard to the date of award.
Same also. It's a perennial problem. I don't know.
No, but then there must be something on record to show when this award was.
Yes.
So it is there. It is there. Date of award is there.
Date of award. We couldn't obtain the copy of the award yourself.
No, but then what is the date? That would suffice. We do not need a copy at least for deciding the thing. But then what is the date of award?
No, Lordship. We could not obtain that also.
No, but then you have to obtain that. That will
No,
be
but
this.
Lordship,
Because we want to verify whether his representation was filed prior to the preparation of the award or after the preparation of final.
We'll answer that.
Because of that issue, my lordship has given time to the respondent to obtain instructions.
Anyway, please proceed. And then what happened after you filed representation?
But the collector did not respond. And because of that, my lord, we filed a writ petition before the Supreme Court. And the learned single bench passed an order that my writ petition is premature. I came before this court, which is the wrong forum. I should have approached to the collector under Section 18 reference. So that was the argument advanced by the respondent. The argument advanced by the respondent was accepted by the learned single bench and passed that order. I say that, my lord.
Section 18 is for?
Yes, reference, my lord.
For enhancement?
For enhancement of reference.
Not for reports on?
Yes. So I have a grievance with that order. We prefer writ appeal. And writ appellate court, we take the plea that I cannot invoke Section 18 because my name was not there and no award was passed in my favor. Therefore, there was no question of.
Definitely, that appears to be correct. How Section 18 would come on once you are not included in the list of claimant, then natural. I don't think Section 18 would not come.
Right. So that argument was advanced before the learned division bench. Learned division bench accepted that argument, set aside the single bench order, and remand back to my lord. And the case is today. And now they have taken the.
What is your prayer here?
Prayer is for my lord directing the respondent to acquire and pay the adequate compensations in accordance with law.
But then, if whether your land is acquired or not, how this court will decide it?
My lord, that is to. I will come.
See, Section 18 is not only the sole remedy available to you. Had it been, say, supposing we're there. See, in this kind of thing, you should go approach this thing. You are free to file a title suit. Do not expect that this court will go into this thing and will decide.
But I'll cite some judgments, my lord. In the case of land compensations, my lord, whenever disputes arise between the landowners and especially the respondent state, my lord, the party never go for, the issue never relegated for filing before the civil suits, civil courts. Now, if I file a suit, my lord, Lordship can appreciate, I'll file a suit against the government. Government is not claiming ownership. If the government claim ownership over my land, then that becomes a civil dispute. I can go to civil courts. Here is the case, my lord, the government admittedly taken the position that, yes, the entire stretch, government has acquired it. Yes. And now your name is not there. The affidavit. So now we issue a notice to you, but merely issuance of Section 9 notice will not confer any right upon you. Now, under Section 9, they have mentioned my house, the trees, number of houses, number of the trees in the Section 9. They have done it after survey. They have done the survey.
Assuming it is correct. Now, what says supposing If say supposing just because says your name appears in the section 9 list, how you to establish how much land is owned by you? Is it shown in section 9 record?
They have mentioned.
Section 9.
They have mentioned.
Your area is mentioned.
Yes, it is mentioned there, my lord. It is mentioned there. That is the grievance. And admittedly, my lord, one aspect is that they did not cancel the section 9. If they said, no, we by mistake, bona fide mistake, we issue notice to you. In fact, you are not the landowner. Mr. Z is the landowner. They could have cancelled it. They did not cancel it. Till today. The only ground taken by the government, the collector and the respondent state is that the report given by the extra commissioner has proceeded to the list of landowners or the report given by the district council. In fact, in the eye of law, district council has no role to play. But admittedly, collector himself robbed in the services of the district council. Now, my only contention, my lord, the report given by the EAC also, my lord, 4 names are missing. And that is my names. That was the plea taken by me. And they are not, my lord, in the affidavit.
So the two facts. One is that the issuance of notice to you under section 9.
Yes.
Disclosing therein the details of your property.
Right.
Coupled with the fact, the missing of those names. This will go to show that your land was acquired. And the government is duty bound to pay. This is what you...
That is a brief case of the petitioner here. And on the showing of the records authored by the collector himself, not by me.
Now, say supposing if your name is shown in section 9, will it be a conclusive proof of your ownership of land?
Right.
Can a writ court take it as a conclusive evidence? Right. Do you have any law?
Right.
You have any law, any direct law with regard to that?
My lord, I'll come to that, my lord. Section 9 notice was issued after prima facie acknowledging my lord, the ownership of the occupants of the persons, my lord. Section 9 lordship, let's see together, my lord. Even section 9 contemplates issuing notice to occupiers, not necessarily, my lord, the landowners.
No, that is all right. That is all right. But then see, whether you occupier or owner, to prove that both things you need evidence. That is the main thing.
My lord, that is true. And therefore, my lord.
So that is what I'm just. This court is asking a question: whether issuance of notice under section 9 can be taken as a conclusive proof of your ownerness or your occupation, as the case may be,
my lord,
over the land.
My lord.
Now, what basis you say it?
My lord, that is my lord. Issuance of
Because
section 9.
See, if you come to section 11,
yes,
that says that if any award is prepared, that should be taken as a final evidence. Against you. But then section 9, no such language is used. Used.
Yes. Section 9 notice is a window open to the landowners, the occupants, to address their grievances. And thereafter, my lord, the collector will proceed for section 11, award, passing award. Now, my grievance is that, my lord, the collector issue a notice to me under section 9, mentioning the details of my properties. And now that deserve, my lord, section 9 notice deserve to reach to a logical conclusion. But without a hearing.
See, section 9 is a notice basically which is issued to you.
Yes.
Asking you to place the nature of your interest.
Yes.
Just because this notice is issued to you, it not mean that you've been taken as a owner. It doesn't say so. The language says, you see, like you have to come because section 9 notification can be issued to either to owner or to occupier.
Occupants.
Or to any other person who is not there Even the last clause, if you
Yes,
see clause
yes.
4,
Yes, yes.
okay, but he is neither present, okay,
Yes.
and nor receives any notice. The section 9(4) makes it mandatory on the part of the authority to issue a notice
Right, right. Now,
to the address where he is residing.
Yes. Lordship kindly see subsection 2 of section 9.
Yes.
Now, this only section notice 9 can be issued after the collector exhausted section 4, section 6, and section 8 measurement of land. Now, in the section 4, or we can say declaration section 6, 10 persons' names are reflected. And now they issue this notice. My lord, a person whose name is not mentioned in the section 6 declaration also may come forward. That, see, you have come for measurement of my land, over my land, and you are not including my name in the section 6 or section 4 declaration. Therefore, this is my case. This is my interest. This is the opportunity for the landowners or the occupants.
Even then, you see, you do not have a solution here. Your solution basically lies before the collector. Section 30 is there.
Lordship, section 30.
See, here the section 30 will come into operation.
Lordship, section 30, let us see together if Lordship permits.
This is the apportionment.
But
see, section
my humble
30.
submission
Your
is,
case totally falls under section 30.
Lordship referring to section 30. Well, with Lordship permission, may I read out? Dispute as to apportionment.
Yes.
When the amount of compensation has been settled under section 11, if any dispute arises to the apportionment of the same or any part thereof, or as the persons to whom the same or any part thereof is payable,
yes,
the collector may refer such dispute to the decision of the court.
So you have to raise that issue. Have you filed any application under section 30?
No, no.
Then?
No, my humble submission, my lord.
Earlier thing, see, earlier writ petition was correct. Instead of mentioning section 30, section 18 was mentioned. That is what. See, this is the only solution you have. What else?
No, my lord, my humble submission is, my lord, my case will not fall under section 30.
Why?
My lord, it is a, my lord, here Lordship kindly see the apportionment of compensation.
Yes.
My lord, here the government has taken a decision that we are not taking your land. Government is saying that they did not take my land.
Yes. Government decided to distribute this amount amongst others, not you.
Others.
But then you say, I also have a right to claim. So section 30 comes.
My lord.
That is what.
My humble submission,
See,
my lord.
probably these are two things. You see, like land acquisition, section 1894, two things. One is dispute with regard to the rate, section 18 comes to play. Dispute with regard to the ownership, section 30 comes into play. This is the solution.
My lord, here, therefore, if there is ownership disputes, my lord, if there is ownership disputes, then one may invoke to section 30. But here is no ownership dispute.
Is there, what is the limitation period for section 30? Anything like section 18, anything prescribed?
Section 18, my lord.
Section 18 is a limitation.
A limitation
What about
is there.
section 30?
Section 13 limitation is not there. Not there.
So, if say, you may still have the opportunity of filing an application.
Yes.
Before the collector, go file it.
Lordship, I'll satisfy. Well, I'll satisfy. Lordship, kindly read section 18.
See, section 30 has been incorporated in spite of the provisions of section 4, 6 and 9. So even section 11 also. Section 11, if you come here, section 11 is
Inquiry in award, my lord, by collector.
just see, read subclause 1, section 11.
Subclause 1, my lord. On the day so fixed, or any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated pursuant to notice given under section 9. Lordship kindly section 9.
Yes.
To the measurement made under section 8. And into the value of the land and at the date of application of section 4, subsection and such, and into the respective interests of persons claiming compensation, and shall make an award under his hand, such and such.
So that will make clear section 9 is not a conclusive proof of ownership.
My lord, it is not
So
conclusive.
there cannot
It is
be
a
a dispute
process.
with regard to that. Now, your claim is based on that. You are saying that since Section 4, Section 6, after following Section 4 and Section 9 has come,
Yes.
and since my name has been reflected there, so I should be treated as owner. Law doesn't say so. It becomes conclusive once this award is
My
made
lord, award
between
pass.
the parties there. You
My
see, like
lord.
between the collector and the parties, those who are.
Now, the award pass under Section 11 is also not conclusive evidence of ownership of the parties.
Definitely, that is why
It is
section,
subject to, my lord, disputes under Section 18.
see, conclusive proof about racing. See, then you go to civil court, go to establish your right. That is one option is there.
Right.
Otherwise, so far as the act is concerned, Section 90, Section 30
My
is there.
lord, one explain.
Section 30,
My,
if you can show some law that Section 30 will not apply in your case.
my case is, my lord, if there is a Mr. Z who is disputing my ownership,
Now,
then I will go to.
just you have filed an application in the September 2013, you say.
Yes.
Now, what happened to the status of this application?
Nothing. He doesn't pass any order.
This could have been treated as an application under Section 30 and could have been referred.
That also, but he did not pass any order.
Can you do it now? Will it be barred by limitation? Is there any bar? Mr. Khan?
I don't think so, Lordship. But Lordship, then before we
If that be the thing, then we'll tell you. See, are you disputing the fact that the petitioner has filed a representation?
Lordship, we are not disputing it, but Lordship will see the content of the Annexure 10. Let us see that application under Section 10.
Doesn't say anything about ownership.
Nothing. No documents have been annexed. Nothing.
Anyway, we'll just come here.
Documents
Let
are
him
required to
come.
annex.
No, we'll not disturb Mr. Sangre.
Yeah,
Otherwise, you will say that court has disturbed.
Now here my contention is, my lord, if another third person is disputing my ownership, I also claim, he also claim, then definitely one has looked to the provision of Section 18 read with Section 30. Now here is
not agreeing with your proposal.
No, here is again.
See, any person who is interested
But-
in the proceeding
but now-
and who finds his name is missing, Section 30 will come to his rescue. That is there.
My lord,
If you want
I'll
to say
place
that
one
Section
decision.
30 will apply only in case there are a dispute between two persons, that is not a correct interpretation.
My lord, assuming, my lord, for the sake of argument, assuming that, my lord, I need to invoke Section 30. Section 30, my lord. There is no one, my lord, who is claiming interest against me, including the state government.
Everyone, those who have got into, see, you say the stretch of land which has been acquired, the others have got benefit. Even if you say that your land has been acquired, that means benefit for that land also have gone to others.
No. My lordship can stands corrected. I don't say that I have a 10 acres of land and that compensation for 10 acres of land has been given to others.
So it means it
this
is not
wrong.
acquired.
That is not my contention. But my contention is that government is acquiring from here to Police Bazaar 100 meters, and between 100 meters, I have also 10 meters of land, and that is also part of the acquisition.
So
And
is
your
it
report,
100 meters has been acquired and your land falls under
My-
that 100 meters.
yes.
That is what, that is exactly what. And this entire compensation, do not take it, divide it individually, collectively take it this thing. It is for that 100 kilometers. So that is what.
My lord,
So amount for your land has been paid. The acquiring department has already paid it. The collector has dispersed it. But then it has not gone to your pocket. Instead, it has been apportioned in a wrong way. Without calculating your thing. That is what your case is. Section 30 comes here. That is why Section 30 is there. We will not make this issue bigger, Mr. Sangresh.
I
We will
understand.
Just
I
a small
understand,
order,
understand.
this can be disposed.
I understand. Lordship, only one submission. I'll place one judgment. But there is a case in 2004 also, where, my lord, the identity of the particular land acquired is not known.
Not known. Identity. Here we do not have identity, difficulty with identity of land.
My lord, my land, they say that they did not acquire.
Here the problem is with the ownership.
But same thing, my lord, there in the Supreme Court also, the identity of the survey area, where the exact area claimed by the parties is
But in
acquired
your
by the
case
government or
doesn't
not.
refer to identity.
No.
You see, it is not a case where you say that your land, though falls under same thing, it has not been included. It's not your case. We do not have any problem with identity of the land. Your only case is that, see, the out of the entire stretch, my land has already been acquired. My land has also been acquired, and I have not paid the money. That is your case.
That is my case.
You can
And
give
the
it. There is no problem. We'll
the
satisfy
reply of the
you.
government is
See,
that,
we'll
my
take
lord,
it
they are not acquiring they didn't acquire my land. The reply of the government is that they don't acquire my land.
They have not acquired your land.
Yeah, yes. Now, therefore, the issue whether the land claimed by me
Show us the apex
is
of
part
that.
of the acquisition or not.
We are
In
getting-
those circumstances, my lord, I've given the citation 2004, volume 12. My lord, spot inspection was directed by the Supreme Court to the officer and give a report to the High Court, and High Court can take a final decision. My lord.
What is the dispute in that case?
My lord, here also it appears it's a very short judgment.
Yes.
May I just read from, my lord, number para 2 only, very short judgment. The controversy appears to be in relation to which specified portion of the 10 acres, 20 gandas in all private surveys and such, corresponding to government new surveys and such, is acquired having regard to the notification under section 46 of the LA. It is contended on behalf of the appellant that in this area of 10 acres, 7 gandas, several persons are staying, having erected huts, structures, and they are living as tenants. This position is seriously disputed on behalf of the respondents, contending that those persons who are claiming to occupy 10 acres, 27 gandas, have no right whatsoever. The owner of this portion of the property are not before us and have not challenged the acquisition proceeding. The all land survey numbers and such corresponding to new surveys and such village from the record, it is not possible to say which portion of the said survey number is acquired. Unless that position is clear, it is difficult to say one way or the other. In the circumstances, we think it just inappropriate that the status quo existing in relation to such and such said to have been acquired as to the position should be maintained. In this regard, it is appropriate that the city survey officer who visits the spot and demarcates the such and such said to have been acquired having regard to the section 4 and 6 of the Act, after notice to both the parties. The said officer shall submit the report to the High Court within a period of 8 weeks from the date of receipt of copy
It's
of
all
this
right,
order.
see.
No, to
It is, you see, not possible to say which portion of the said survey number is acquired.
My lord.
That is what,
My lord,
here
here
it is
also,
not the
my lord.
dispute.
My lord.
Here it is not a question or dispute. See, the identity of the land which has been occupied, there is no confusion with regard to that. Only thing is that you say that certain portion in that entire stretch, it belongs to me. Money should be given to you.
Right.
So that will be decided in section 30 application. It has nothing to do with these things. It is not a case where land could not be identified.
My lord, therefore, I am urging, embracing before my lord, the lordship even can direct to conduct the inquiry by district judge and give a report to lordship. That will give you a clarity instantly. Otherwise, my lord, that one option of section 30, as the lordship has pointed out, that is also there. But admittedly, on records.
No, once if Act itself has the provision, there is no question of this court going and you see like interfering in land acquisition proceedings. When there is a law, specific law, operating and holding the field, there is no question this court coming and you see like exercising jurisdiction under 226. If that remedy is available in the Act, you should follow the Act, mandate of the Act, nothing else.
And lordship may kindly see my
If you
application.
can give us some more direct decision, honestly, the decision which you have referred to in here does not apply to the facts and situation. See, paragraph 5 here make it amply clear. It is not possible to say which portion of the state survey number is acquired. Here we have no problem with this. Unless the portion is clear, it is difficult to say one way or the other. Here we do not have any such problem. And that is the crux of the issue there.
My lord, according to me, it has a bearing here also. Certain area which, my lord, the portion is owned by me. Government is saying that
That
it
is
is not
okay.
acquired.
See, you see, the main thing is that your claim is something different. It doesn't You see, like it is not identical to what has been reflected in this apex court judgment. Anyway, we'll record it. There is no problem. If that satisfies you, definitely will do.
Only my lord can you see the section 9 notification? Notice
Yes. One
and
minute.
representation
One
I
minute.
show.
1 minute.
Only
Just hold. Yes. Where is that?
My lord, page 125.
Ajay,
is the-
before that, just where is your survey by district council and where is the survey by extradition commission?
I show. My lord may come to section, sorry, page number 24, annexure 1. This was the letter issued by the collector inviting the district council to render their service.
No, where is the?
Now,
that is.
I'll
Where
come
is
to
the
the
survey
report.
report of?
The report, my lord, the report given by the joint survey team is page number
You were pointing out to the letter issued by the collector to the
district council.
district council.
Yes.
Asking their.
Yes, their assistance for conducting survey.
Where is that one? That
Page number 24.
24.
My lord. 28 August 2010. Pursuant to that, my lord, district council, page 25, has deputed 6 revenue staffs. Page 25.
Then where is the report?
Then, my lord, the report is page number 26.
And where
It's a
is your
joint
name?
report given, my lord. Here, 15 land owners are mentioned.
And where is your name?
Now, my name is not here also.
This is the.
Is a joint.
But then this is a report by the district council, isn't it?
No, joint report given by the collector and district council. Page number 26.
So that is joint report.
Yes, joint report. And after this joint report was placed, there were many complaints that many names are not included. Therefore, the district council, I'll come to that, my lord.
So your name is not there.
My name is not there.
Where your name is there?
Now, I'll come to page number 74 now.
70?
74. Annexure 5. Now, because of that numerous complaints, district council also conducted a fair survey and they have given a report.
That is of their own.
Of their own, madam.
Of their own.
Yes, of their own.
What relevancy it will have?
My lord, since the district collector has invited them to take part in the survey activities, therefore they have done this. Page number 74.
And where is your name?
My lord, here, serial serial number, Lordship, can you see 45, 48, 49, and 50? I'll come to page number. Lordship, can you come to page number 86? Serial number 45, Mary T. Marak. She's the writ petitioner.
Just a minute.
Her house particular lands are mentioned. Details are mentioned like others.
Srimati Mary D. Marak.
Yes, Mary D. Marak. She is one of writ petitioner. And my lord may turn to next page, 86, 87.
Wait, just a minute. Just. Page 87, what is that?
87, writ petitioner number 2, 3, and 4, my lord. Serial number 48.
How many petitioners are here?
Only 4 petitioners. 4 petitioners.
4 petitioners.
4 petitioners.
All are similarly situated.
Yes.
And this all have written representation on the same day.
Yes.
These are joint. Joint.
Is a joint. Is a joint representation. My lord may kindly see serial number 48. Nicholas, writ petition number 2. 3 is 49.
50.
50. Pangsrang Samba.
Who is this 43?
My lord, Hudson is writ petition number 3.
43 is the petition number 3.
But no. Serial number 48 is the writ petition number 2.
Just a minute. 43. Who is 43? Julie D. Marak?
No.
No.
No, my lord.
So you start from 45.
45. Serial number 45
yes.
is the writ petition number 1. Serial number 48 is the writ petition number 2.
48 then?
49.
Yes.
And 50.
Okay. Four writ petitioners.
4 petitioners.
Yes.
They are detailed, their house, the area of land is mentioned. Now, this was submitted to district council, to the collector, and thereafter, my lord, may turn to page number 96, report submitted by EAC.
Yes.
EAC. Now, the report submitted by the EAC is 22nd November 2010.
Yes.
And the report given by the district council is 26 November. So 2 or 3 days difference is there. Now,
26 report of district council is 26 November.
Yes. Subsequent to EAC report. And because of that, collector in his affidavit said that he has given precedent to the EAC report. Now, in this report,
in the EAC report, you are not there.
My name is not there. Now I will show, my lord. Here they have mentioned, my lord, 75 landowners in the EAC report. And now in 75 landowners, 4 serial numbers are missing. And I'll show to my lord that one. These are
prepared by two different authorities. The serial number may not tell you.
I'll show, my lord.
How, on what basis you will say?
I'll show you, lordship. Just bear with me. I'll show how, my lord. Lordship, may kindly turn to page number 104 of the EAC report. It's the serial number.
104.
104.
Yes.
My lord, the last serial number is 45.
Yes.
Lordship. And the next page, 105.
Yes, yes.
It is started from 50. 50. And this is not disputed by the collector. Now, 46, 47, 48, 49 are missing.
It starts from what numbers? 50.
My lord, may kindly see the last page number 104. Serial number ended at page at serial number 45. And
yes, after
105.
serial number 45.
Yes.
You can turn to the next page, isn't it?
Yes.
And then we find it starts from serial number 50.
50. So 4 persons are
so
missing.
45 to 46 to 49 missing.
Missing. These are 4 persons. So my claim is that these are my names.
On what basis?
My lord.
On what basis?
Well, this is because they are lifted from the district council report.
Relying, this is a
council.
reliance. This, how do you say this is relying from the district council report?
My lord, it was a survey conducted jointly also earlier, my lord.
Now that is the first one.
It's the last one. And now I have taken that plea.
That is the first survey. That is the first survey where DC writes to the district council seeking their help.
Yes. So
then report comes. Your name is not there.
Yes, not there.
No, but then how come there will be an imputation that these missing names appear to you?
Now I have taken that specific plea. Affidavit, they are not denying that.
No, you have taken a plea, but then justify the plea. Taking your plea is not sufficient. The court is asking you about how do you justify it. What is the basis? Is there any legal say proposition that it has to be treated that the missing names are your names?
Well,
now, had it been a case where both the reports are prepared by the same authority, we may go by that presumption. But then it's totally different. And page 96 has no reference to the report of the district council. So just because 4 names are saying, how do we come to the conclusion that this is your name?
My lord, that was the plea taken by me.
You are contending doesn't mean that you cannot contend. You contend, but then how do you tell us to accept that contention? That is what matters.
I have taken that plea, and it is the duty of the government to deny it if it is wrong. They did not deny it, then presumption is very clear.
So they say
that amounts to exception by the government.
do not deny the fact that these names
amounts to admission.
Now, certain stretch of land has been acquired.
Yes.
It has certain measurement. In the report prepared by ESC, which you have referred just now, it has names of many claimants.
Yes.
Except the missing names.
Yes.
Now, if you take together the area of land shown against the name of each claimant, if you tally it, will it come to the exact amount of area which has been acquired?
That is why. That's why it requires.
No, you have to tell us. Just tell us. Try to understand the query. Say, supposing 100 square meter has been acquired. Okay, a list is prepared containing 75 names or whatever it is. Now you say 4 names are missing.
Yes.
Minus these 4 names, if you add up the area shown against the name of each and every claimant, will it tally and come to 100 square feet?
Well, that revenue officer will know that one.
No, but then area is shown here in this thing report. It's not shown.
Well, area, my lord, area.
What is the
amount of area they show? But the stretch.
I don't know whether court was able to convey you the.
I got.
100 square meters. Now, what the court wants to know it minus your inclusion in the list, whether area comes to 100 square feet or not, or square meter or whatever it is.
My lord, the report did not show that one. Report only show.
No, report doesn't show the area of this thing.
Yes, report show the area of the individual person.
Yes,
but report did not show the entire stretch of 100 meters.
What is the actual portion of land acquired?
My lord,
what is the total area of land acquired?
My lord, it is not with the privy of the.
So how do we find it out?
My lord, we are the landowners. My lord, if the highway comes to my curtain, back of my house, I know it, man. But that doesn't mean that I should know
so how
the
much
entire stretch.
Land has been acquired that has not been mentioned in section 4 or section 6?
But we'll come to the section 4. But
just see. You see, like
section, it is section 4 and section 6 declaration. They have mentioned. But lordship query is whether 75 names mentioned in the report, including the areas, will also exactly the same area mentioned in section.
This is a normal assumption. Okay, a stretch of land is acquired. Now, in that stretch, there falls area of many individuals.
Yes.
So, each and every area of individuals are identified. Yes. And when you add up all those areas, it comes to the exact area which this entire stretch belongs.
Yeah, right.
So, that is what the court's question is.
Yes.
Now, court question is that minus you, the name of all other claimants, and if their areas are taken up together, whether it will come to the entire the stretch of land which has been acquired.
My lord.
Now, if there is something less, we can say that yes, your name has been left out. Say 100 square meters or square kilometers have been acquired, and if we add up everyone, we come to 96. Then we can relate it to the missing names and say that yes, that 4 square kilometers of meeting and this belong to you.
Well, I understand the query that falls for my lord. Now, EAC report did not indicate the area of the entire 100 meters. For example, 100 meters. They only mention 75 persons and their areas. Now, 75 minus 4, it is only 71 landowners they have mentioned. Since 4 names are missing, so only 71 landowners are there, including their areas. Now, this area is not the exact area because in section 4 notification, it was reduced to 56 landowners only, including the area. Now, let us see the section 4 notification. Page
Section
number
4 is before, isn't it?
No.
Section
Prior.
4 came fast.
No, I don't.
See, wait. Section 4, it was Section 4 notice is the first notice, isn't it? Now, it contained name of 56 persons. And the final list contains 71 names.
My lord.
So, there is an increase.
My lord, yes.
Now,
may I stand corrected? Now, these reports are preliminary in nature. Now, this report was prior to section 4 notification.
Which report?
This EAC report, District Council report, joint report.
EAC report is dated what?
My lord, 22nd November 2012,
Just
page number 96.
Page 96 dated?
22nd November 2012.
And when is the report of the District Council?
Report District Council is 26 November.
This is page
number 74.
This is dated
26 November 2012.
After the EAC?
Well, after 2 days of EAC submission.
Not 2 days, 4 days.
4 days. 4 days.
If you cannot, if you're not good in arithmetic, take assistance of agent. Well, and then what was the date of the joint thing survey?
A joint, my lord.
Joint report?
The joint report.
Come to page 24, page...
My lord, page number 26.
Yes.
It appears, my lord, it is, my lord, 27/11/2011.
2011.
My lord, the different dates are mentioned. May think, my lord, some signatories, they mention 5th September 2011.
Achha.
So
Then
this is
what is the date of section 4 notification?
Yeah, prior to section 4.
Section 4 notification?
Now, section 4 notification is 14 March 2023, page number 110.
14/3?
2013.
This is annexure?
Annexure 7, page 110. And my lord may keep in mind, 56 landowners are mentioned only.
It's all right.
Well,
it's a preliminary.
It's a preliminary.
Doesn't matter.
Preliminary. Therefore, EAC report.
Cannot be a basis for giving any findings.
Therefore, EAC report, District Council report, or joint reports are preliminary in nature. Preliminary in nature. Now, the actual, my lord, the proceedings.
See, everything merges with the award. Now, how many people are there in the award? How many are enlisted as beneficiaries?
Right. Now, that one, let the, my lord, the respondent may disclose. Section 6 declaration may show, my lord. Date is, my lord, 23rd May 2023. Section 6 declaration.
23rd May.
May
13. Yes.
Now they
This is
mention
page-
what?
This is page?
Page number 113. And 120 landowners mentioned.
What is the date you said? Sorry, Mr.
23rd May 2023. 2013, sorry. 2013.
Yes.
Page number 113. 120 landowners. Thereafter, my lord, my
section
9
56
notice.
56 owners.
Yes.
Section 6 is 120. 121.
Yes, it climbs to 120,
Yes.
which is in fact unusual. Now, Section 9 notice.
Why unusual?
My lord, it is unexpected, my lord. The Section 4 notification is issued after collector done the preliminary activities. So, when they come for Section 6 declaration, climbing up to that.
This is the confirmation of acquisition. But this, so far the number of notices is nothing. The finality is 11, Section 11.
Award will come in. How many people they have given that they will.
Finally, how many people became beneficiary? That is the award wins. All other things are process. It's part of process.
In the process.
And finality is 11.
Yes, in the process. In the process. Now I may show Section 9 notice to my lord. Page number 125.
Yes.
Notice is, my lord, 9 July 2013.
9 July.
Well,
yes.
Page number 125.
Yes.
Well, their lands, houses, the trees are mentioned. And
Measurement of the land is mentioned?
Land also mentioned. No.
Measurement of the land?
Measurement of the land is mentioned.
Have you, if we add it up, how much it comes?
My lord, that...
Tell us. Then that will be conclusive. That will help you. If you show that, because Section 9, your name is there.
Yes, it is.
Your area is also there.
Yes.
Now, if you add up all those things and if you say that it comes to exactly the land which stretch has been acquired, your matter becomes clear.
But they have given in revenue number, Lordship kindly turn page 125. What exact area? It is not mentioned in the my lord one letter.
Can we go into that deep to find out?
This is
what will be the law, Mr. Khan?
Lordship, this is basically what the exchange that is happening right now between the court and the petitioner counsel is exactly what should have been done or ought to be done under Section 30 if they file an application.
Exactly.
We are grateful that the court has undertaken
this. Court has
is
expressed that view right at the beginning, that Section 30 is the only solution.
Lordship is correct.
And these are the exercise to be taken up by the...
Absolutely.
Now, it seems Mr. Senior Counsel is not satisfied with that. So...
He may be given chance if you got any other authority.
What this court is looking for is...
Also asking a very
if there is some apparent wrong on the part of the authorities. That is what we are trying to find it out. Otherwise, it is not possible for this court to go into these things. Why this court is saying that you add up all those things and just see whether part is missing?
If I may just
then you come and say this part is missing, this is my land.
Absolutely correct.
Now, in your petition, how much land you say that you own?
My lord, in my petition.
Yes.
My lord, that particular.
Lordship, before he answers the query, Lordship, I'll just formulate one question for you, Lordship. Your turn will be hearing you. You'll have to reply certain things. It is not that matter is not ending with No, we are very well.
Matter is not ending without
ending. It's not so simple. We are very
well. First you come to 125, page 125.
My lord, Section 9 notice.
Yes.
Lordship can is page 125.
Yes.
It says notice is given that PK or these are the my lord revenue land measurement number. Page number 125, Lordship got it.
BKL or...
Yeah, this is the area, square my lord, more or less of land of trees number. Here, picture they don't have, it doesn't have a tree. Houses, Paga, Semi, Assam
these are
type
all
2.
notices to you?
Yes, notice to me.
So, but then there is no this thing, measurement of land.
No measurement of land, no boundaries.
Measurement of, my lord, boundaries. It is not mentioned, my lord. As per notification, they have mentioned.
So at first notification means the general. They enter everyone.
Yes.
My lord.
Correct.
Now they have mentioned my area, PKL, my lord, square meter. He has 2 Assam type house. Lordship kindly mention.
No. It doesn't say you have.
My lord.
Notice is given to you, but then it's only so far as the detail of the thing is concerned.
Yes. That notice given to me.
Type house? Which one?
2 Assam type.
Where? Which page?
Page 125.
Yes.
Number of houses, Assam type 2 Kacha, situated at
there
Songsan.
Is Assam type 1.
Yes.
Then Assam type 2. Then Assam type 1.
Now the page number 126, he has, my lord, 180 trees, one Assam type,
Yes.
and petition number 3 is, my lord, 53 trees, two Assam type house,
Yes.
my lord. And last petitioner is 130 trees, one Assam type.
Yes. But
My
this
lord.
falls in which area? Boundary is not given.
Boundary as per the notification.
That is what.
My
So
lord.
this means entire.
Therefore,
that means this is a part of this entire stretch.
that is for, it is the duty of the
That is the evidence which we do.
my lord. That is the duty of the
So
collector.
this goes in your favor or against you?
But definitely, my lord, they should be more particular. But he has mentioned it. But the mistake committed by the collector cannot be the ground for me to deprive. My lord. And he has mentioned as per the notification, and my name is mentioned.
Anyway, anything else?
My lord. So this is, and last, my lord, my application is page number 129. After they did not give me a hearing, and I put up the application for hearing,
129.
page 129.
Yes.
My lord. 13th September 2023. Now, third paragraph, that being called upon by the letter saying and such, we have turned to the concerned authority for hearing. We have been aggrieved to receive certain information from the concerned authority that the list of inclusion of our names in the statement of valuation was found lost, and we returned without attending the hearing. That we have approached the detailing authority and requested them to search for the lost list. On being asked repeatedly, the detailing authority have searched for it, and we have been informed that lost list of inclusion of our names is found. Having found the list, and as DC in charge for the revenue is also transferred to pursue the work without delay with new DC in charge, we submit the application. Therefore, in view of the above stated facts and circumstances, we aggrieved landowners sincerely request your honor to kindly fix another date for hearing. So this was a request made by us. From thereafter, my lord.
You write a date, letter for fixing another date for hearing in September.
That is, my lord, 2 months. 2 months of the
Yes,
notice.
you are asking for another date.
But
you appear in July.
July 19.
And then you wait
September,
for
October.
You wait for entire August.
No.
And then in September you want another date.
My lord, less than 2 months. Less than 2 months I wait.
No, but
I
then
put
what?
up.
If you want a fixation of date, what period of 2 months is this is done
Well,
immediately? The same day it should be informed that we could not participate in the hearing because of the paucity of time. You give us time again.
My lord.
You do it after 2 months.
But I could have done it earlier also. But see the content of the letters. There was an interaction, my lord. Indicates that I continue to approach the dealing authorities.
Okay, carry on, no problem.
So this is my submission. So there was no, according to me, there was no deliberate delay on our part to put up this application. So my humble submission, my
When did
lord.
you file this writ petition, Mr.?
My lord.
This writ petition was filed which year?
2017. 2017.
Now your application is 2013, where you asked for fixation of date.
Yes.
Now it was not done. You waited
Not
for 4 years and then you came to file the writ petition.
My lord. Thereafter, we put up the, my lord, RTI application, to page 133, and they have given a reply.
What information you asked in RTI?
My lord,
thing?
all those are the details of the land, the compensation documents. Proceedings, kindly see page 131.
So you did not pursue your application for fixing a date for hearing?
Since, my lord, since we have placed, it is a duty of the authority to fix it, my lord. Now the RTI application is, my lord.
Page 131.
My lord, 131.
Yes.
This was put up on in the month of, my lord, 1st September 2015. And they have given the reply, my lord, 28 September 2015.
So what is the queries you have this thing?
Well, these are the land compensation documents we asked for. And the reply would be interesting, my lord, the last page, page 134.
When did you file this
My lord,
RTA application?
RTA application 1st September 2015, page number 132.
2 years after your last application.
It's a continuous process, my lord.
Why not? You can continue some more also. There is no
Why?
problem in it.
And the reply was given.
That is your liberty when to file an application or not.
Now the village level lordship may appreciate that they came up with this finally. Reply is page 134, 28 September 2015.
Yes. What
They
they
have
say,
given
what
the
is the
details.
reason they have given?
They have given the section 4 notification also, EAC report also.
No, no, what is the reply they have given?
Reply may not become to page 134. Reply number 1 is the section 4 notification they are giving. Copy. Serial
No,
number.
That does not reply that your query, isn't it?
They are answering my queries.
No, see, come to the first question which you have placed. Come to page 131.
Yes, 131.
Okay. Now come to paragraph 2. Then subparagraph I. Then subparagraph 2, paragraph A. The reasons or ground upon which the names. Could you get it? Page 131, annexure 11.
Page 131, okay. Okay. Well, you
have come, see paragraph 2. Particulars and information required, you've seen?
Yes, particulars, yes. Request.
Yes, okay.
Subject matter of information.
Subject matter of information, then subpara A, isn't it?
Yes.
Skip the first part, come to the
The reasons or ground.
Yes, yes.
My lord, the reason or ground upon which the names of the beneficiaries of land compensation in respect of such. My lord, were removed from the final list for payment of
So
compensation.
you ask for the reasons.
Yes.
Now what is the reply to this?
My lord, let's know the reply regarding to this. They did not give a answer for these queries, my lord, this information.
See, come to paragraph 2 there. Paragraph 2 of these things.
As per report, lordship.
Yes.
My lord, as per reports available, this office did not receive any claims or objection from the above name mentions of the publication
That
of
is the
above.
so you are saying that no reply was given?
No.
It is reply was given.
No, my lord, preliminary notification was issued. Thereafter, they have issued me a notice, section 9.
See, they say, as per their statement, they say in section 9, after section 9, nobody has gone to file any claim and objection.
My lord, since they invoke the section 17 urgency, there is no scope for objection. There is a law, my lord. Had they did not invoke urgency clause, then they...
Now, how do you disbelieve this statement if you say that you have made a claim and objection? See, this is 28 September 2015.
Yes. Well.
And they say like, till that date, you have not made any of these things, claims or objections.
Therefore, not only
That
me.
is the ultimate conclusion.
Not only me, my lord. The rest of the 120...
Come to next paragraph 3.
Well.
There is no inclusion of names of the above named persons in the inquiry report.
Lordship,
Conducted
there
under
is no
section 5
inclusion of names of the above named persons in the inquiry report conducted under the section and such as submitted the inquiry officer copies of the such. That inquiry report is EAC.
What is annexure 2? It refers to EAC.
EAC.
Yes.
That missing number is there.
So it's all right. There is missing number
and
until unless you give us something missing number, there cannot be any
My
presumption.
lord.
It
Now,
belongs to you.
EAC report disclosed only 56 names. And the final declaration reached to 120. So EAC report is not the final document.
See,
It's only
annexure 2
preliminary.
is EAC report of which one?
EAC report, my lord, which I have shown.
Which is this page,
Page
104,
number, my lord.
page 96, page 96.
Page number, my lord. Yes. Just page number 96. Exactly.
This contains 56 names.
So 75 names mentioned 75 serial number, but when we
Minus
count
four-
properly,
minus 4, 71.
71 only.
But then where you say 56 names?
But that is, I refer to the my lord, other one, sorry. Stand corrected.
What is
But
this annexure 2 here?
Annexure 2 is the EAC report, page number
71
96.
names or 56 names?
71 names.
So that is what you see, be clear. Otherwise, court will be more confused. You know you're brave. This court doesn't know.
So EAC names is only preliminary.
Now this 22nd November 2012 is before the issuance of Section 4 notification, isn't it?
Yes, they relied. And this EAC report is not the final one. If it is the final one, solely relied
No,
upon.
but then they say that is the source basis on which they say that the name.
But
names.
therefore, my lord, EAC report is not conclusive.
Now, if it happens that the issuance of Section 9 notification, if it is contended by the other side, the Section 9 notification to you is by mistake, then what happens?
My lord, then my lord, that would be the different consequences. If they hear me,
But then what
after
stand the state has taken?
my lord, they simply say in the affidavit that mere issuance of Section 9 do not confer any right upon the petitioners. Only that one. Now, therefore, my humble contention is, my lord, if they hear me, and after when I appear, they said, oh, by mistake, we issue notice to you. You are not the owner of this building, Assam type house or the land, so sorry. May the
But
rich
then
lord-
they have issued notice, and as per the information derived by the RTI, you have not raised any claim or objection.
my lord, if that is the,
Is it not that there is a presumption about the correctness of the government record?
no, my lord, why the reason why I say no, because they issue Section 9 notice to me after Section 4 notice.
No. After Section 9, you did not file any claim or objection.
But therefore, I appear before them. And my contention is that you're not hearing me. I'm saying to the collector, you're not hearing me. You asked me to appear on 19 July. You're not hearing me.
Anyway, Mr. Khan, just tell us how many beneficiaries are there in your ultimate award.
In the award will show me.
Kindly show us the names of the beneficiaries
In the award.
in the award.
Lordship, that is where exactly the problem is.
If that is the problem, then you have to...
No, Lordship, my submission would be we have...
Any affidavit filed by the state?
Yes.
What stand you have taken in your affidavit?
Lordship, our basic stand is that we are relying on the EAC report.
And
rightly said because...
Section 9 doesn't confer any right on
It
that.
doesn't confer any right. And the RTI one that there was no claim and objection. And Lordship, annexure 10 is very crucial. They file an application for refixing the date for hearing after 2 months, September 30th.
This court has taken note of all those things.
If you see the contents of the letter, Lordship, they're not in any...
Now, one thing is that if at all any application was filed by them,
right,
as appears in why it was not referred under Section 30?
That is a different issue altogether. Absolutely correct. But that was not an argument forward. Neither the case was before the division bench
This is a case
or
which
single bench.
should
Yes.
only fall under Section 30 and nothing.
Yes, Lordship is correct.
Yes. Okay. Now, if at all there appears to be somebody interested,
Yes.
apart from those who are
Yes.
enlisted as beneficiaries,
Correct.
their duty is to come and file an application before the collector
Correct.
and get it referred under Section 30.
Absolutely
That
correct.
is the only thing.
They
We
never
don't
argued
have
that.
to make things so complicated.
They have never argued before single bench, nor before division bench, even now.
See,
This is
the
the third time
Reed
here.
Court cannot confer the
Yes.
right of ownership of them
Absolutely.
because to say that they should be entitled to compensation, there has to be, the court first has to be confirmed in its view
Lordship.
that they are the real owners.
Absolutely.
And we do not have sufficient mechanism to do that. We
Lordship,
cannot do
I was about to
Now,
formulate-
only thing is that you just tell us that the award. How many names are there in the award?
Lordship,
When the award was prepared,
Lordship, way back on 28 November 2023, after when the matter was heard, we had written to the Deputy Commissioner. My colleague had written to
when is the date of award?
Lordship, we have got no instruction on that. That is.
No, but then you take this instruction. This is relevant.
Lordship,
This is
very
must.
relevant, Lordship. If
That is a
need,
must.
Lordship, if need be, because on 28 November 2023, we had written to the Deputy Commissioner to kindly give us the award in detail. Nothing has come forward.
No, but then if they not come, then we will call the deputy commissioner.
Absolutely. I was coming to that, Lordship. Let him come with the records.
There should be at least they should have the information about the award. If they are claiming to be personally interested, they must know about the award.
Lordship, even in the entire RTA application.
No, you do one thing. When did you write? You said
28 November 2023.
Anyway, 2023. I do not know. I think before we pass an order for personal thing, I think it's better we communicate.
Lordship, kindly bear with
Let
it.
this election be awarded.
Absolutely, absolutely. I was about to
because
come
this
to that.
award would be very much needed to see the list, and just also to see that missing things which you are saying, how they answer it, and we'll just also take into consideration how much the entire stretch and how much money was paid for the thing, whether the money was paid for the entire stretch or certain part was left.
Lordship may pass some judicial order. Earlier, Lordship did not pass. They just simply made prayer.
No, we'll pass an order asking them to,
Then they have to comply.
give information about this.
Yes.
Copy of that.
And if judicial order comes, will be
This is what.
And Your Lordship, I was about to submit one important issue of facts, rather, not law. This is the entire argument that was forwarded. Keep aside everything, Your Lordship, whether Section 9 or the representation. Even after the representation, RTI, and then even approaching this Honorable Court, is there any whisper of any title documents annexed with the... Now, prima facie, if that was existent, then we could have built up an
Is there
argument.
any
Nothing.
details of their property in the...
Absolutely no.
What is the measurement of your area?
Nothing. No area measurement, nothing.
Lordship, in one way, the respondents say that this Honorable Court cannot enter into the
No,
title of the...
No,
I'm asking you a question. Is there any narration
Yes.
of details of your property? Where is that?
Any supporting document to...
Just let us first see whether there is evidence.
That was the moot question before we would have started the argument. If at all.
Well, Lordship, kindly come to additional affidavit we filed.
Additional affidavit.
Additional affidavit.
Why it is not in your main writ petition?
Exactly.
Do they get a chance to reply? No. If it is factual aspect, if they do not have a chance to reply to it, we will not take into this. This you know, Mr. Shabdesha.
Well, if they want
Additional affidavit is only with regard to the affidavit in opposition which is filed by the state. Now, if you bring in new facts, how they will rebut it?
my lord, if they want, my lord, we filed in 2019.
No. That is cannot be a unending process about filing pleadings. You file writ petition, you will find affidavit in opposition, you file rejoinder, then you will file reply to the rejoinder, then again you will find objection to the reply to the rejoinder, then you will give re-rejoinder to this. Cannot, writ court cannot move that.
I'm not, my lord.
No process, you see.
Right.
Even filing of rejoinder is not a matter of right.
Right. Absolutely.
It's only when court permits it.
Yeah, my lord.
Probably we overlook all those things nowadays.
When the court grants leave to the
writ
party.
court is becoming just like any other court of any other civil court. You see, it cannot be something like that.
Right.
Anyway, so far as your writ is concerned, there is no statement about the details of your thing.
Well, it is not elaborately highlighted. Yes.
No. In your writ petition, is there any statement with regard to your property? Details
Yes,
of
we,
your
we are the landowner. We have stated that one, but the particulars of the area, we do not mention it.
So there is nothing.
Now the additional affidavit, my lord.
Wait.
Para
We'll come to original affidavit.
No, Lordship, allow me that the question that I have formulated, I'll just have to clarify further.
You say it is there in rejoinder.
In the additional affidavit.
In additional affidavit.
Affidavit we filed on 11th September 2019.
Dated?
Dated 11 September 2019. And here it is not the case of the respondent that I am not the landowner. If they say...
You cannot build up a case on the weakness of the other side. We'll just see what you have stated. If it is not rebutted, definitely is different.
Therefore, my humble argument, they cannot raise this issue.
You see, you cannot build a case on the weakness of the respondent. It
That
is
is
for
true,
writ
that is
petitioner to prove his own case.
My lord, that is true. That is true.
Now, what is the paragraph? Additional affidavit?
My lord, paragraph 3 would be more detailed, my lord. Paragraph 3.
Any documents in support?
My lord, here some documents issued by the NOCMA also there, my lord. Annexure 1.
Para 3, there is no documents annexed.
NOCMA, you see, at that relevant point of time, it was a district council, isn't it? NOCMA had no authority with regard to the settlement of Lloyd.
My lord.
NOCMA, is there any power authority available to NOCMA to issue land?
But my lord, the customary practices is that, my lord, the entire area here is a NOCMA land. And if the NOCMA
NOCMA gives confirmation and district council issues.
My lord, that is before the division bench allocation we placed.
You are questioning that part,
that is
but then that is the process all along which was in existence, especially during the time when this acquisition came.
My lord, what happened?
Anyway, details of property.
No, Lordship, we just come to the annexure itself, please. That will clarify.
It's okay, Mr. Khan, we may not go into evaluating all those things.
Lordship, two very important things, even in this NOCMA, Lordship. Lordship, we just come to annexure A1, page 8 of the additional affidavit. They filed. Issue is issued by NOCMA, but no area mentioned, neither the boundaries.
Additional affidavit filed on?
Filed on 11/9/2019.
Just a minute.
The question that I want to formulate, Lordship, I just want to answer by the one affidavit. Even we take the affidavit.
Court may not go into all those things. You see, till now, court's mind.
Lordship, annexure A1, page 8.
Page 8. Yes.
Lordship, first thing, there is no date. Second, the area is not mentioned.
No, there is no signature, no seal, nothing.
Lordship, I'm coming to that. No date, no area mentioned, no boundaries.
Yes, Mr. Sangdesho, can it be an admissible piece of evidence?
My lord, original one is page 9. 8 is a type copy. Page 10 also same thing, type copy. Original is page number 11.
There is no
Lordship cannot enter into all these aspects. Lordship will examine the procedural aspect of the matter.
We
That is the issue.
Cannot enter into those.
Lordship, he is correct. We cannot enter.
We are correct.
Absolutely correct.
Tell us about the award, Mr. Khan.
Lordship, that an order can be passed. Lordship. As I submitted, Lordship, 23rd November 2023. So, now because of the ensuing elections, maybe.
No, that is okay. Election.
Some judicial order may be passed, Lordship.
The election is tomorrow, I think.
Tomorrow.
Anyway, I think they may remain under election commission for some more time. I think till the.
Your Lordship, at least the issue has been cleansed by your Lordship, so there is hardly any. Except for that, the rest need not be answered with the state.
See, nothing has been cleansed. But then, so far as the section 30 is concerned, that is still remaining in the mind of the court. Now, that is what is the main thing, Mr. Sangrejo. Because normally, if for settling certain dispute, if there prevails a law, so we should follow the mandate of that law.
Correct.
We will not travel beyond that to give you some extraordinary relief.
Lordship, like even if I may just
if you say that some of the procedures are not followed,
yes,
then definitely
there's a different thing. There's a different.
That is not your case.
Like
your case is that your name is not included.
Lordship, the stand of the state would be even on section 30 would be. You can knock the door and enter section 30 when you have prima facie documents to show that a portion of the land was part of the larger land and you were not paid. First, he has to say where he stands. Then the question of entering 30 comes. Admittedly, Lordship, there is no document and I show document in annexure A1.
If I came forward voluntarily, then government would ask, where is the documents? But here the government came forward that you're the landowner. We're entering your area.
No, we
Come
never
forward.
said. No, we never
Say that is section 19. What section 9 says?
How? I'm feeling a bit aghast, Lordship. We have taken a stand. Section 9 does not confer title. He doesn't have document. He wants to become owner by virtue of section 9. Is it permissible in law?
It's all right.
Anyway,
I don't think there should be much exchanges so far as section 9 is concerned.
Nothing remains in law.
We understand that it cannot.
It's almost like Lordship. It's almost like going back to our civil court days.
Section 9 issuance of section 9 notification.
For grant of any injunction, we have to have a prima facie case. And what is the title document?
Just say. Like hard Mr. H. English Learned Senior Counsel for the petitioner. And also Mr. K. Khan Learned AG, appealing for the state. It transpires that the details of the award prepared in connection with the acquisition proceeding, which is subject matter of this petition, is required to be placed before this court for a just and proper adjudication of the matter. The state respondent is directed to produce a copy of the record, place a copy of the award.
Absolutely.
Before this court, award in question before this court on the next date of hearing. When? The list is matter after 3 weeks. That is what we just see. If award can make out a case. But then, Mr. Sangalesh, if you can bring something
I'll see
with regard to section 30, yes, please. That will be because decision which you have furnished, probably the facts are a bit different. The facts and situation. Because there is a problem with regard to the identification of light in view of existence of two surveys.
Yes.
Two surveys. But then here it is not.
It's nothing.
Here you're not these things. Your thing is that, see, I am also a owner. My land has been acquired and I have not been paid compensation. That is what your case is. Please try to procure these things as early as possible. If you fail it in, we may extend another date for this.
No, absolutely.
But then do not take it as an advantage. Just try to do it. I think.
Absolutely correct. Lordship is very correct. At least
please,
that will be crucial.
And please convey you to your officer that if he fails to do it, then some serious order may follow.
Absolutely.
As you have said that you have already communicated.
Lordship, yes.
And probably I think he cannot ignore the letter sent by you.
Yes. Now that the judicial order is coming, Lordship will communicate as soon as possible.
Highly
Item number 13.
Yes.
My lord, I need some time for this, my lord. If it could be taken after 2 weeks, I need instruction. What is the status of the civil case, my lord? This is a petition for, we are aggrieved by non-hearing of the matter of seizure list, my lord. When the keys of the shop was handed over to a respondent, I was not heard. So last time...
Jimma, matters pertaining to Jimma.
Jimma, yes, my lord.
2 weeks.
So I need some instruction, my lord, on...
Private respondent, there is a private respondent, Mr.
Yes, my lord, number 2.
Yes, my lord, there is one.
Has he entered appearance?
No.
Was he served, Mr.
Not yet, my lord. Yes, we have submitted the certificate also.
Yes, already they have filed an affidavit bringing records. He has been served, but then he has chosen not to appear. This is reflected on order dated 15th February.
Well, if it could be taken after 2 weeks, in the meantime, I will know what is the present position of the civil case.
Yes.
Accordingly.
Yes, Siddiqui Learned Senior Counsel briefing for the petitioner. Prays for grant of 2 weeks' time to enable the petitioner to verify the status of the civil case, having bearing in this matter. Pending before
Before the
trial court.
Sorry, district judge, my lord.
Pending before the court, pending before the district judge.
No, it is at the appellate district judge.
It's okay. Pending before the district judge Shillong. Learned Counsel for the state has no objection. Trial allowed, list after 2 weeks. Yes.
Item number 21.
2 weeks, Mr. Siddiqui.
Highly obliged.
Item number 22.
Yes.
Please, this was a quashing petition.
Application under section 482.
Quashing of what case?
Case under section 279, 2337, 338, 427, 304 AIPC.
Motor vehicle accident, Your Lordship.
Rash and negligent driving.
Rash and negligent driving.
Yes.
I'll just take Your Lordship to the facts, Your Lordship.
Yes, please.
Your Lordship, on 6/9/2019, an accident had occurred in Light Core. Your Lordship, the petitioner was on a motorcycle, and the deceased victim was the pillion rider. Your Lordship, what has happened is that on a sharp turning, another vehicle who was driven by the complainant had rammed us, and the pillion driver or the pillion had expired. After this incident, what had happened, Your Lordship, we were immediately taken first to the civil hospital for a medical, and the deceased victim was rushed to Nickels in view of his serious injuries. And after that, on the 9th, the pillion rider expired.
These offences are not compoundable.
Non-compoundable.
279 is not compoundable. Your
And
Lordship,
304A.
304A is also not.
Otherwise, parties have compromised.
Compromised.
They have compromised.
Anybody appearing for the
Other
private
two.
respondent? You have, so you have compromised. Yes, all right. What is the stand of the state, madam?
Your Lordship, in this case, Your Lordship, the person who was riding the motorcycle, Your Lordship, was a young boy of 18 years. He had no driving license, and he was driving the motorcycle in a rash and negligent manner, and he dashed against this vehicle which was coming from the opposite direction and turning to the left. So, and this rash and negligent driving cost the life of the pillion rider who was riding behind him. So my submission is this, Your Lordship. They may have compromised, but my submission is this, Your Lordship. How can a young boy who has no driving license, driving rashly in a public road, Your Lordship, be allowed to go off so leniently? This can be repeated again, because it is not a case against an individual. It will cause...
Licenseless driver, basically, it's an offence against the state, isn't it?
182.
So
license.
This mere compromise between the parties.
What is doesn't help, Your Lordship.
What you will say about?
How can he be allowed?
So supposing if the law says that you can drive a vehicle after obtaining a license, but then apparently you drive a vehicle without license, and then you met with accident. Now, is it not that is a violation of certain requirement of law, and the offence is against the state, and your compromise will have no relevancy here?
What should be not mistaken, Your Lordship, section 182 of the Motor Vehicle Act is a compoundable offence which can be compounded upon paying a certain fine of 1,000 before the trial court.
Now, here the offences alleged under 279. 279 is rash and negligent driving.
Rash.
And then 337, 338, 427, these are what?
One is mischief, Your Lordship.
So these are not license related offence.
182 is the license.
Only
So
182
if
is
182 is compoundable, then what is the objection then?
No, Your Lordship, my thing is that when a young boy without a license is driving a vehicle on a public road, causing, posing,
But then 182
posing
is compoundable.
risk to the public,
But then this compoundable is what? How, to whom you can compromise?
you cannot compromise
Yes.
with any private party. You have to compromise with the government.
With the state.
Lordship, in
And we are not a
other
party to this
circumstances, Your
compromise
Lordship,
deed.
if I just draw an analogy, if I'm driving without a license on a road and no accident occurs, I'm now caught by the police. Lordship, all I have to do is pay a fine there, and that's the only condition, Your Lordship. And the best will be remanded to court where I have to go and
No,
appear.
but then see,
and pay.
compromise has to come with the state.
Yes, sir.
Cannot be a compromise between the private parties.
Private parties.
For an offence of this. If it is compoundable also, then there has to be compounding with this thing. You see, like you cannot come and compromise with others and say it is compoundable.
Lordship, if I'm not mistaken, I'll just get instruction whether it is 182. If I'm not mistaken, has already been compounded by the trial court upon
Definitely,
paying
you
of the
can do
fine.
that. That you can do that. Definitely,
Lordship.
definitely.
Because if
So
that
what
is
are the-
compounded, Lordship, then there's no need of
Okay,
quashing
so
that
what is the other
particular
offences
provision.
are concerned? Okay, we may have a look at your compromise.
So the other offences are stated the rash and negligent driving, Your Lordship. Your Lordship, mere accusation of rash and negligent driving ipso facto does not prove that there's a negligent driving. And I'll satisfy
Anyway,
that.
You see, like the consequence of your rash and negligent driving.
Has caused the life.
Yes,
cost
but
the life
I'll
of
just
somebody.
take Your Lordship to the FIR and to the statement given by the complainant, and I'll establish that there's no rash and negligent driving, Your Lordship.
The FIR says that he is
Anyway, you see, once you are seeking quashing on the basis of compromise,
Yes, that's why we
you
don't
will
want
not
to enter the
enter into
merits,
those
Your Lordship.
controversial areas.
Yes, I do not want to enter the merits, but since they've raised on merits, I would have to reply. Your Lordship, may just have the FIR, Your Lordship, speech.
Just a minute, just a minute.
Has fine been paid? There's nothing, no statement here. Then we can find it.
Now, 279 also is not compoundable, isn't it?
No, Your Lordship.
No, sure.
Then, in such a case, you have to have a compromise with them only, with the state.
Speaker, the sections are.
See, your this petition is based on compromise.
Yes, Your Lordship.
So we will not go to any other issues. We will not enter into any other controversial area or the area where parties have conflict.
Yes, Your Lordship.
Okay. So only thing is that whether this compromise can be acted upon for quashing this case or not.
Yes, Lord.
Okay. Now that is what is to be seen. Now 297, since it is not compoundable, and if it is to be compromised, then it will be compromised by with whom?
There's no 297, there's only 279, Your Lordship.
279. Sorry, 279. Then
Lordship,
whom?
my
279
humble
is-
submission, Your Lordship, the coordinate bench of this court also, in similar matters, have exercised jurisdiction on 482 and quash proceedings.
Same section of law.
Same, exactly, and the facts are exactly identical, Your
Give
Lordship.
us that. You give a copy of the judgment to the other side also.
Yes, sir.
Yes, madam. She is referring to certain decision. Have you come
No,
across
I am
that?
not aware of that.
Kindly have a look on this.
Decisions by this court.
In this matter also the sections all are 279, 338, 427 and 304A of the IPC.
Same section.
Same section, Your Lordship.
182 was there. License? No.
It was 185 was there.
185 was there, Your Lordship.
What is that 185? MB Act.
MV Act, Your Lordship.
What is that 185 MB Act?
Exploring. Your Lordship, driving under by a drunken person under influence of alcohol.
But then 182 is with regard to license.
License.
Madam, you just go to this division and in the meanwhile he will let him take instruction with regard to the...
Whether they have
Yes,
Whatever
182.
he has pleaded guilty on that.
But then was there that is a case, it was based on a compromise.
Compromise.
Compromise by? Between?
Parties, Your Lordship.
Private parties.
Private parties. The relative of
And
the
what was
deceased.
the stand of the state here in this case?
The same objections were raised that these are rash and negligent driven on the same manner, where it can be
The state,
compounded.
did the state oppose?
They oppose, Your Lordship. I'll give another citation of a similar case.
Same court.
Now the question will come, who can enter into compromise? That is the main thing. This issue has not been gone into by the judgment.
No.
Neither it has been raised by the state. State was basically harping on 304A.
That's a heinous offense.
Saying that it's a serious offense and all, so this should be taken. But then who should be a rightful person to enter into compromise, that was not the issue. So that way that judgment cannot bind this court. If at all this is an issue raised by the state. And apparently Madam is raising that issue.
In view of the Motor Vehicles
You have
Act
to work in
provision.
that area.
So I'll just get instructions whether the
No,
offense-
definitely. Your thing will also enlighten the court also.
Because if that is compounded by trial court, then there's no need for questioning that particular provision. We don't have to enter the question.
We'll go to the citations submitted by my learned friend now. And then there are some other citations referred to in these judgments also, Your Lordship. So then we can...
In this judgment, the
yes,
judgment
in this
which-
judgment there are other citations.
There is that
also.
apex court judgment about the compromise in Narinder Singh case.
Narinder Singh, yeah.
Yes. So I'll just...
So Lordship, our submission would be if
My submission
the
is
parties
that
are compromised, then the entire proceedings before the trial court will be a futile exercise, Your Lordship. Because what they'll be stating here, they'll be stating in the trial court as well.
What about 182 of MB Act?
Just on that, I'll get instructions, Your Lordship. Because if I'm not mistaken, the offense has been compounded. Because these kind of offenses, once this.
Rash and negligent driving.
Yes, Your Lordship.
Otherwise, if it doesn't result in any accident, but in your court, then what happens? You are caught by the police.
Your Lordship.
And there is no private respondent on the other side.
Yes, Your Lordship.
Then with whom you compromise?
Basically, there have been matters, Your Lordship, where even the FIR has been filed by the police officials itself, and whether such petitions could be quashed and
That
compromised.
is one arena you require into.
we'll have to examine that. Your Lordship.
Yes, this kind of situation hardly comes. Now, this questioning on the basis of compromise is a result trend. I think it started after the apex court judgment in 2012 and all, where it said that where offences are not compoundable,
Then they can come and
yes,
quash it before the High Court.
and in suitable cases, court will definitely do that. Now, thereafter, we find that many cases are coming basing on the compromise. Now, the compromise, see, if you come to section 320, now talk about compounding offense. Now,
For the
with whom
parties-
it can be, it is laid down there.
Yes. But in these
The tabulation, it is there. But so far as compromise is concerned, what would be the thing? Will it not go by the same proposition which has been laid down in 320 so far as the compromise is concerned? It has to be with the same authority. Now,
because
in non-compoundable cases, we do not know with whom.
Lordship, to address who would enter into compromise, we have to look on section 279 with the allegation of rash and negligent driving, and we have to argue on the merits. If we establish before this court that there was no rash and negligent driving, the section goes, and as such we do not have to argue on who could enter into the compromise.
Then
Does
that
to
will
mean
be a matter of evidence, Your Lordship.
Your Lordship, it's already before.
Then the proceedings.
That means we have to go through the rigor of trial then.
Your Lordship, I can even satisfy right now that there's no rash and negligent driving because the examination in chief of the complainant has already been taken.
That is to be see in 482.
But the cross-examination is yet to be
482
done.
will not
fact that
analyze.
If you go through the FIR, Your Lordship, FIR has been filed under pressure.
FIR is not a conclusive proof so far as the criminal trial is concerned. It is information based on which investigation starts. Now, thing is that if you want this court to go into the evidence, 482 will not do.
So there's a Supreme Court judgment that mere
But
allegation
you
of
see, the application here, right from the beginning, the court was saying that your application here is based on a compromise.
Yes, Lord.
Okay, so whether this compromise can be acted upon for quashing or not, that is what is to be seen. Whether the private party has the authority to compromise an offence under section 279 or not, that also has to be seen.
My submission would be the
Because once you break
279,
the
Your
law-
Lordship. You must understand that the Supreme Court is very clear on this, and mere allegation does not ipso facto provides that there was a rash negligent driving. I can provide the citation to Your Lordship, and Your Lordship may
This
just
matter has been charge sheeted.
charge it, Your Lordship.
evidence
Evidence
going
is going
on.
on.
Trial is
So
going
where is
on.
the question of going into all those things mere allegation? Now it is not a mere
Now it is
allegation.
not a-
Now there is a charge sheet.
Yes, Your Lordship.
So,
Your Lordship, if we go
so
through
you cannot fix that word, prefix that word mere allegation.
Lordship, can you appreciate where the accident occurred? If you go through the statement of the complainant, there was a sharp turn, and the vehicle what has gone is gone on the opposite. The statement is very clear.
To do sexual aspects.
can
Confine
go into
yourself
all
to
that,
this.
Your Lordship.
Confine yourself to this agreement,
Who
compromise,
is compromise?
and say that this compromise can be acted upon.
Enter.
If you can show that, you succeed.
Okay,
We will not go into any other things.
I'll satisfy Your Lordship.
And just take these things. 182, you will definitely take instruction. 279. And the other offences, what are those?
Those are mischief. 304 is
Causing death by negligence.
causing
Okay.
death by negligence.
Okay.
Let's see. Three three seven is also there, Your Lordship.
304A can be compromised.
It can be. Your Lordship.
It can be.
There's been many instances.
304A, Your Lordship.
There is a
on-
decision of
on
2000
payment of fine, one can compromise.
Miss 2019, I think there is a decision of Apex Court with regard to the compromise. I think.
Just check.
Lakshmi Narayan.
Probably.
That is also there.
Is it 307 case
Yes,
involving? is it?
307. Yes, Your Lordship. Where even the Narendra thing has been referred, Your
Yes,
Lordship.
yes.
Citation.
Anyway, we'll just say.
We'll do that, Your Lordship.
I'll just get instructions, Your Lordship, on that. is fine.
We'll just say. We'll just say simply give you time without saying anything.
Yes, sir.
To seek further instructions.
What about the citation? You to be written?
Lordship, I have it. I will refund the next day.
We can keep it in the record.
Yes, Your Lordship.
You are Mr. Pasa?
Yeah, Pasa, Your Lordship.
Mr. A.R. Pasa, Lord Counsel appearing with the petitioner. Please for grant of some time in order to obtain further instruction in the matter. The state has no objection
No, Your Lordship.
to the prayer meet. Stop. List after when?
2 weeks, Your Lordship.
Prayer allowed. List after 2 weeks. Please see it. These are coming to a quite interesting arena. 279 and all those things. Matter may be small, but then
But it is
quite see.
technical also.
No more.